This is attorney Simon Aziz Budhwani, partner and trial attorney at Core Law Group. I can be reached at 949-505-2479. Today I'm going to talk to you a little bit about a DUI arraignment, when it occurs, where it occurs, and generally how to deal with it and what to expect. Let's start with the first topic. When does it occur? It varies a little bit, and it depends on two factors. The first is whether you're still in custody. If you are, it happens within 72 hours of your arrest. If you've been released from jail, either on your own recognizance or if you've posted bail or bond, then it usually occurs around 30 days from the date of your release. That's when it occurs. Where it occurs depends on which county in California you were arrested or stopped in. If it's Orange County, your case will be in Orange County, one of the courtrooms here. If it's LA, it'll be in one of the LA County courtrooms. It depends on the documentation you receive from the police when you are released. At that point, you will be told a date in your paperwork and a location to show up at. It's critical that you either show up yourself or have an attorney show up on your behalf. If you don't, then a warrant can be issued for your arrest, and we don't want that to happen. So it's critical that you either have an attorney show up for you or that you show up yourself. Now, we've talked about when and where. Let's talk a little bit about what to expect. The arraignment is the opportunity where the DA presents to the court and to you what charges are being alleged against you. For a DUI, typically, they are Vehicle Code 23152A, which is count 1, and 23152B, which is count 2. You may ask why 2 counts stemming from one DUI. Well, the answer is pretty simple. The DA wants 2 bites at the apple. They want a backup. 23152B says that you were driving with a blood alcohol level of 0.08 or higher. A, on the other hand, says that you were just driving with alcohol in your system or drugs in your system. So even if your blood alcohol level comes back below a 0.08 and they want to prosecute, they can based on the A count. So now we've talked about the when, the where, and what the charges usually are. There can be more charges than 152A and B. 23152A and B. If your blood alcohol level is high, there can be an enhancement added to those charges. If you refused your blood or breath test, they can add refusal to your complaint. So the DA can play with it. Now, how should you normally deal with an arraignment? Well, at the arraignment, you're going to be given 3 options. You could either plead guilty, not guilty, or no contest. Just those 3. It's not like TV where there's testimony and evidence presented at the arraignment stage. That comes later. But at the arraignment stage, the court just says, here are the charges against you. You want to plead guilty, not guilty, or no contest. If you plead guilty or no contest, this is your punishment. If you don't, we'll move the case along. Generally speaking, it's this practitioner's opinion that at the arraignment stage, it's a bit foolish to plead guilty unless you have a really good offer. Reckless driving or drunk in public or an infraction of some sort. The reason why I think it's a little bit foolish is because an arraignment, pleading guilty at an arraignment is kind of like poker. If you're pleading guilty at that stage, you don't even know what cards you have yet. Or better yet, what evidence or cards the DA is holding. Unlike poker, in a criminal case, the DA and the government have to give you all of the evidence they have against you. However, that doesn't happen until after the arraignment. So if you accept a guilty plea or a no contest plea prior to or at the arraignment, then you are pleading guilty before you even know what evidence they have against you. They might have nothing. There might be technical errors that the police make. So it's smarter, in my opinion, this practitioner's opinion, that a not guilty plea be entered and the case be moved along, evidence be obtained, reviewed, analyzed, and then a determination to be made whether to accept some sort of a plea or take the case to trial. That is basically what an arraignment is, when it occurs, where it occurs, so on and so forth. My name is Attorney Simon Aziz Budhwani. I'm a trial attorney and partner at Core Law Group. I can be reached at 949-505-2479. Again, that's 949-505-2479. Thank you and have a blessed day.